Welcome back to the deep dive. Um, Today feels a little different.
Yeah, he really does.
Usually, we grab a stack of sources and we're looking for productivity hacks or the history of coffee or something that's just purely fun and fascinating.
Right?
But today we are looking at a stack of documents that are, quite honestly, they're heavy. I spent the last 2 days reading through these, and I have to admit I had to put them down and walk away a few times.
It is a really heavy stack. It's
Yeah,
one of those topics where the more you read, the more you realize that what you thought you knew, what common sense tells you, is just completely wrong.
exactly.
You realize the intuition is backwards.
Right. So let's set the stage for you listening. We were talking about comprehensive legal analyses from the UIC School of Law. We have these really searing critical reviews of appellate court cases from the Center for Women's Justice.
Dr. Charlotte Pradman's work there is incredibly intense.
It really is. Plus, we've got international human rights declarations from the UN and then some very practical legal perspectives from family law firms like RJS.
So it's this mix of the theoretical, the statistical, and the very grim reality of what actually happens in a courtroom.
And our mission for this deep dive into the source material is to try and unpack the intersection of domestic violence and child custody. Because I think most people have this assumption, and I know I did, that if a relationship is abusive, you leave.
Right? You could get out.
You leave, and then the system steps in, it protects the kids, it keeps the bad guy away, and end of story.
That is the exact narrative we are sold. It's what you might call the intuition model of justice.
But the sources,
Yeah.
the sources tell a story that is almost the exact opposite of that intuition.
Completely the opposite.
We are going to look at why leaving often increases the danger rather than decreasing it. We're going to look at why being a friendly parent, which, sounds like a good thing.
Sounds great on paper.
Yeah, but why it can actually cost you custody of your child. And we are going to look at data that completely upends what we think we know about false allegations.
The distinction you just made there between intuition and reality, that is going to be the thread we pull on for this whole conversation.
Because it's a big thread.
Huge. Because the family court system, as described in these sources, is operating on a set of assumptions that honestly haven't been updated in about 40 years.
Wow.
And the cost of that lag is measured in the safety of children.
So let's start with that first big assumption. The UIC source calls it the separation myth. And I think this is where most of us live. We think violence is situational, like, oh, they just fight a lot. They're a volatile couple.
Right.
So the logic follows. If they separate, the friction is gone, so the violence stops.
It appeals to our desire for logic, doesn't it?
Yeah.
If a fire is caused by two sticks wooding together, you pull the sticks apart and the fire goes out.
Exactly.
And that is exactly how many judges, custody evaluators, and even psychologists view domestic violence. They see it as a product of the relationship dynamic.
But the data in the UIC analysis says that's dead wrong for a specific type of violence.
It is dead wrong for coercive control, or what we call abusive violence. The source highlights a statistic that just stops you in your tracks.
Tell me.
Women separated from their partners report violent episodes at a rate 40 times higher than those still married.
40 times higher.
40 times.
That is staggering. So the moment the court assumes is the start of peace is actually...
Start of the war, yes. Because you have to understand the motivation of the abuser. If the abuse is about losing a temper because someone burned the toast, maybe separation helps.
Right.
But if the abuse is about ownership, if the mindset is, I own you, I control you, you do not exist without my permission, then separation is the ultimate rebellion.
Because they're losing control.
Exactly. It is the ultimate loss of control. So the abuser doesn't just shrug and move on. They escalate. They engage in what the literature calls separation assault.
So when a judge looks at a couple filing for divorce and says, well, you're separating now, so we don't need to worry about those past incidents, they are essentially ignoring the most dangerous window of time.
They are looking at the match right as it's being thrown into the gasoline and saying, well, the match is no longer in the box, so we're safe. This is a fundamental misunderstanding of what the violence actually is.
And this ties directly into the harm report mentioned in the Center for Women's Justice source. This was a Ministry of Justice report in the UK, right?
Yes. And it was a landmark piece of work. They essentially audited how the courts were handling these specific types of cases.
And what did they find?
They found a systemic pro-contact culture.
Pro-contact, meaning the system is biased toward ensuring the child sees both parents, no matter what.
Essentially, yes. The overriding principle in family law, and this is true in the US, the UK, Canada, Australia, is that it is in the best interest of the child to have a meaningful relationship with both parents.
Which sounds reasonable on the surface.
It's the gold standard for normal divorces.
Hmm.
So the system is designed to facilitate that. It is designed to clear hurdles to contact. The problem is when abuse is just seen as a hurdle to be cleared rather than a fundamental safety risk, you get incredibly dangerous outcomes.
So the system minimizes the danger.
The culture minimizes the abuse because acknowledging the full scale of the abuse would mean stopping contact, which goes entirely against that pro-contact philosophy.
It feels like the definition of violence itself is part of the problem here. When I hear domestic violence, and I think when a lot of judges hear it, they think of a physical fight, a punch, a slap, a broken arm.
Right.
If there are no bruises, is it really violence?
That is the million-dollar question. And the UN Declaration on the Elimination of Violence Against Women, which we have in our stack, is very clear that violence is much broader than that.
Okay.
The CDC definition utilized in the UIC source backs this up too. Violence isn't just physical. It includes sexual violence, it includes stalking, and critically, it includes psychological aggression.
And the UIC source spends a lot of time on this concept of coercive control. I feel like this term is getting a bit more mainstream, but I still don't think people realize it's actually a legal concept now in some places.
It is becoming one, but the courts are definitely lagging. Coercive control is the framework. It's not about a single incident.
What is it then?
It's a pattern of behavior intended to monitor, control, and threaten. It's checking the odometer on the car to see where she went. It's giving an adult an allowance of $10 a week. It's isolating the victim from their friends.
Wow.
It's making the victim feel like they are going crazy, which is what we call gaslighting.
It's a cage.
It's a cage made of invisible bars. And the problem, as Dr. Prodman points out in the Center for Women's Justice Analysis, is that the legal system is built to adjudicate incidents.
Right, like on June 12th, did he hit you?
Exactly. And if the answer is no, the court thinks, okay, no violence. But if on June 12th, he spent 4 hours interrogating you about who you talked to at the grocery store until you were sobbing on the floor,
That doesn't fit on the form.
it doesn't fit on the form.
The CWJ source notes that while the Court of Appeal in the UK has finally acknowledged coercive control as relevant, historically, it's just been dismissed as unhappy marriage stuff.
Exactly. They call it history. Or they say, oh, it's just a toxic relationship.
I really hate that phrase in this context, toxic relationship, because it implies parity. It implies, oh, we were just bad for each other.
It implies mutual responsibility. We just push each other's buttons. But coercive control is almost exclusively one-sided. One person is the jailer, the other is the prisoner. You don't look at a prisoner trying to escape and say, wow, those two really have a toxic dynamic.
No, you say that person is being held against their will.
Exactly. But because the bars are psychological, the courts struggle to see the jailer.
And this brings us to the kids. Because the other big myth, and this is one I think even I held on to a little bit before reading this, is the idea that if the violence is directed at the partner, the kids are sort of innocent bystanders.
Like they're just in the background.
Right. Like if the dad hits the mom, but he's nice to the kid, isn't the kid okay?
That is the most dangerous myth of all. And the UIC law source completely destroys it with the science of ACEs, adverse childhood experiences.
I've heard of ACs. This is pretty standard psychology now, right?
It is the bedrock of modern developmental psychology and pediatrics. The American Academy of Pediatrics has weighed in heavily here. The consensus is absolute. Witnessing abuse is abuse.
There is no such thing as just witnessing.
None.
But explain the mechanism to me. If I'm a kid and I'm in my room playing with Legos and I hear screaming downstairs, I'm not being hit, why is that damaging my body?
Because human beings are not built to ignore threat. When a child lives in a home with coercive control, even if it's just quiet, simmering tension, their body is in a constant state of hyperarousal. We're talking about the HPA axis.
The hypothalamic pituitary adrenal axis.
Exactly. This is your stress response system.
The fight or flight mechanism.
Right. In a safe home, that system turns on when there's a danger. A dog barks aggressively or you trip and fall, and then it turns off.
You go back to normal.
Yes. But in an abusive home, that switch gets taped to the on-end position. The child is practically bathing in cortisol.
Cortisol being the stress hormone.
Right. And cortisol is toxic to a developing brain in high doses over long periods.
Toxic how?
It literally changes the architecture of the brain. It shrinks the hippocampus, which is the part that handles memory and emotion regulation.
Wow.
And it enlarges the amygdala, which is the fear center. So you end up with a child whose nervous system is fundamentally rewired to overreact to future stress.
The source used an analogy for this. It's like a smoke detector that goes off when you make toast.
Yes, because they are primed for danger constantly.
Mm-hmm.
And the UIC source links this not just to being an anxious kid, but to hard medical outcomes in adulthood.
Like physical health problems.
Severe ones. We are talking about significantly higher rates of heart disease, obesity, autoimmune disorders, substance abuse, and depression.
So the body keeps the score.
The body absolutely keeps a score. You cannot separate the emotional trauma of living in that house from the physical damage to the child's developing systems. It is systemic.
There's also the behavioral aspect mentioned in the sources. Intergenerational transmission. This is the cycle of violence we always hear about.
It is tragic, but the data is very clear. Boys who witness abuse are statistically more likely to become abusers themselves.
Because they're modeling the behavior.
They learn that violence is a tool you use to get what you want. They learn that love involves dominance. And on the flip side, girls who witness abuse are more likely to be victimized in their own adult relationships.
Because it's normalized for them.
Exactly. They're conditioned to believe that walking on eggshells is normal. The fear is just a component of intimacy.
That is, God, that's so heavy.
It is.
But the source does talk about resiliency factors. It's not a guarantee that these kids are doomed, right?
No, absolutely not. Neuroplasticity is real. People can heal. But the UIC source identifies the single most important protective factor for a child exposed to domestic violence.
What is it?
A strong, supportive relationship with a non-abusive parent.
Just one safe parent.
That relationship is the anchor. If the child has one parent who is safe, who is consistent, who protects them, that can buffer a huge amount of the trauma we just talked about.
And here is the cruel irony that the UIC source points out. When the court system forces a child to spend time with the abusive parent, or worse, gives the abusive parent custody, they are often disrupting the relationship with that safe parent.
They're severing the lifeline. Think about it from the kid's perspective.
Okay.
If a child is terrified of their father because they've watched him abuse their mother, and the court says, you must go spend the weekend with him. And mom, you have to smile and wave goodbye or else you're being unfriendly.
Oh, wow.
The child learns that the safe parent cannot protect them. That completely shatters their world.
Because the one person who is supposed to keep them safe is handing them over to the monster.
Exactly. It confirms the abuser's power. The abuser is essentially saying, mom can't help you. The judge won't help you. I'm in charge.
That concept, the friendly parent, we need to get into that. But before we do, we need to clarify something the UIC source spends a lot of time on, which is typologies of violence.
This is a critical distinction.
Because I can hear you listening right now thinking, well, my partner and I scream at each other sometimes, so are we abusive? Are we damaging our kids' brains?
Right. And Johnson's research, which is cited in the source, differentiates between two main types: situational couple violence and coercive controlling violence, which is sometimes called intimate terrorism.
Okay, let's break that down. Start with situational couple violence.
Situational couple violence is what you might see in a high conflict divorce that isn't abusive in the systemic sense. It's mutual. It's often based on poor conflict resolution skills.
Like they just don't know how to argue.
Right. Maybe they scream about money. Maybe someone throws a plate in frustration. Maybe there's a shove. Now, it is unhealthy. It is bad for kids. But, and this is key, it is not rooted in a desire to dominate the other person's existence.
So one partner isn't afraid of the other in a pervasive, everyday way.
Correct. And then you have coercive abuse.
Which is distinct.
Very distinct. It is usually one-sided. It is strategic. The violence, whether it's physical or psychological, is a tactic used to maintain control. The victim lives in fear, and the perpetrator lives in entitlement.
Why does this distinction matter so much for the judge sitting in the courtroom?
Because the remedy has to be different. If you have situational couple violence, you can send them to mediation. You can do what's called parallel parenting. You can send them to anger management. And it might actually work because the issue is managing conflict.
But if you send a coercive controller to mediation...
You are putting the victim in a room with their tormentor and asking them to negotiate.
That's terrifying.
You cannot negotiate with someone whose goal is your destruction or your total submission. It's like asking a hostage to negotiate with the hostage taker without a police negotiator present.
It's impossible.
And if you give a coercive controller joint custody, you are simply handing them a brand new set of tools to abuse the victim.
Like using the kids as leverage.
Exactly. Oh, you want to sign a kid up for soccer? Oh. I refuse permission unless you do X, Y, and Z for me.
This leads to something I see online constantly, the gender parity debate. fathers' rights groups. And we should say, for you listening, we're not taking sides politically here. We're just reporting what the UIC source discusses regarding the political influence of these groups.
Right. The source analyzes their lobbying impact.
And these groups claim that women and men commit violence at equal rates. They have studies that say women hit men just as often.
This is where we have to be very literate about how data is collected and used. The UIC source unpacks these specific studies. Usually they use a tool called the CTS.
The conflict tactics scale.
Yes. It basically asks a survey question. In the last year, did you hit, kick, shove, or slap your partner?
So it just counts the act?
It counts the act. It ignores the context entirely, and it ignores the consequence. So imagine a scenario. A husband has been stalking his wife, controlling her money, and he blocks the doorway so she can't leave the house. He grabs her arm. She scratches his face to get him to let go.
Okay, so on the conflict tactics scale, how does that look?
That is one act of violence for him, the grabbing, and one act of violence for her, the scratching. The study codes that as mutual violence or gender parity.
But in reality, one is aggression and one is self-defense.
Exactly. And when you filter the data for injuries, for fear, and for coercive control, the gender parity completely vanishes. The vast majority of coercive, injury-causing violence is committed by men against women.
But these decontextualized stats are used in court.
All the time. They are used to say, look, judge, she's violent too. It's a wash. Just do 50-50 custody.
That's essentially lying with statistics.
It's stripping context to create a false equivalency. And unfortunately, it works very well.
Let's move into the courtroom itself then, because the sources describe a landscape that is just rigged with booby traps for victims, and one of the biggest ones is this friendly parent concept we touched on earlier.
Yes.
I want to really dig into this because, it sounds so benign. Who doesn't want a friendly parent?
It sounds lovely. It's based on the idea that the best parent is the one who facilitates a relationship with the other parent.
Which makes sense in a normal situation.
In a normal divorce, that's absolutely true. You want parents who support each other's relationship with the child. But in the context of abuse, it becomes a weapon.
Walk me through how it works in practice.
Imagine you are a mother who knows your ex-husband is dangerous. Maybe he drives drunk with the kids. Maybe he's threatened to kidnap them. Naturally, you try to restrict access. You ask for supervised visits. You don't answer his calls immediately because he screams at you.
You're trying to build a wall to protect your kids. To the court, how does that look?
If a court doesn't understand abuse, you look hostile. You look like a gatekeeper. You are actively failing the friendly parent test.
And the abuser.
Meanwhile, the abuser walks in. And coercive controllers are often charming, manipulative, and very calm in public.
Right. They know how to put on a suit and play the part.
They do. So he says to the judge, Your Honor, I just want to see my kids. I love them. I don't know why she's being so difficult. I'm happy to split everything 50-50.
So he looks like the reasonable one.
He looks like the friendly parent. And the heuristic, the mental shortcut the judge uses is he wants to share, she wants to block. Therefore, he is the better parent. The UIC source explicitly notes that abusers are often highly skilled at projecting this non-abusive image while deflecting all the blame onto the victim.
It's a total catch-22. If you protect your child, you look unfriendly and you lose custody. If you don't protect your child, you're endangering them.
Precisely. You cannot win. And this connects directly to the specter of parental alienation.
Parental alienation syndrome, PAS. This is the theory that one parent invents abuse, claims to brainwash the child against the other parent.
Yes, it was coined by Richard Gardner back in the 80s. It has been largely discredited by the scientific community. American Psychological Association, the CDC, nobody recognizes it as a valid scientific syndrome.
But in family court.
It is alive and well.
The UIC source cites a study by Meyer and Dixon, that is. Frankly, it's terrifying to read.
The Meyer study is the definitive empirical look at this dynamic.
Yeah.
They analyzed thousands of custody cases. They found that when fathers are accused of abuse, if they cross-claim alienation, meaning if they say, she's just brainwashing the kids against me, they are more likely to win custody than if they simply defended themselves against the abuse claim.
Wait, so accusing the mom of alienation is a better defense strategy than just proving you didn't do the abuse?
Statistically, yes.
Yeah.
Because it shifts the focus. The court stops looking at, is dad abusive? And starts looking at, is mom being mean?
Wow.
And here's the real kicker. Even when the court upheld the abuse allegations, meaning the court agreed and found that the father was indeed abusive, if alienation claims were also present, the mother lost custody in a significant number of cases.
So the court literally says, we know you hit her, but we think she's bad-mouthing you. And we think the bad-mouthing is worse than the hitting.
That is the functional outcome. The system seems to fear a child losing a relationship with a father more than it feels a child being physically or psychologically hurt by a father.
That entire dynamic seems to hinge on the idea that women lie about this all the time. The false allegation myth. I feel like this is deeply cultural. We see it in movies, on TV. The vindictive ex-wife making things up to get the house or full custody.
It is a massive cultural trope. Fathers' rights groups claim that something like 70% of abuse allegations in custody battles are false.
Is there any data for that 70% number?
There is zero empirical data to support that. None.
Yeah.
The UIC source looks at actual peer-reviewed studies on false allegations in these contexts. The rate of intentionally false allegations, meaning outright lies, is extremely low. We're talking around 1.3 to 2% in most studies.
2% compared to 70.
Yes. Now, are there unsubstantiated claims? Yes. That means there wasn't enough legal evidence to prove it in court. But domestic violence happens behind closed doors.
Right. There usually aren't witnesses.
Exactly. Just because you can't prove it beyond a reasonable doubt doesn't mean it didn't happen. But the narrative conflates unproven with liar.
And the source throws in a counterstat that I found really ironic given the context.
Right. Fathers are actually more likely to make false allegations of alienation than mothers are to make false allegations of abuse.
Yet the system is hyper-vigilant about the moms lying.
And almost automatically believes the dad's claims of alienation. It's a profound double standard.
I want to ground this because we've been talking a lot about stats and theories and percentages. But the Center for Women's Justice source, Dr. Proudman's work, gives us actual cases, case studies. And these are really hard to listen to, but I think for you listening, we have to go through them to understand how this plays out in real life.
We do, because this is where the system's failure becomes deeply human.
Let's talk about the case of Re-H.
Re-H involves a mother who alleged rape. She said the father raped her. The judge dismissed these allegations. And the reasoning. The reasoning is like a time capsule from the 1800s.
What did the judge say?
The judge said that because she didn't physically fight him off, she didn't struggle, and because they had a history of consensual sex previously, it couldn't be rape.
Ignoring the concept of freezing entirely. Ignoring that you might not fight back because you're terrified he'll kill you.
Exactly. The freeze response is a known biological reaction to extreme trauma. And the idea that if you consented yesterday, you consented today is legally, factually wrong.
It's absurd.
But the judge applied these outdated rape myths anyway. Dr. Proudman notes that the appeal, which was part of a feminist judgment project rewriting the verdict, had to explicitly point out that the judge simply didn't understand the law or the psychology of sexual violence.
Then there was Riti, this one. I literally had to read this twice to make sure I wasn't hallucinating what I was reading.
Riti is horrific. In this case, the father put a plastic bag over the mother's head.
A plastic bag over her head?
Yes. Think about the pure terror of that. It is a simulation of execution. It is saying, I can snuff you out whenever I want. He also repeatedly threatened to kill her.
And what did the judge do?
The judge described the bag incident in his ruling as a prank.
A prank.
A prank. And the threats to kill. The judge minimized them because they were said, quote, in anger.
How does that even happen? How does a trained judge look at a plastic bag over a woman's head and write the word prank in a legal document?
This goes back to minimizing coercive control. The judge is looking for a specific intent to injure. Maybe the dad said, oh, I was just joking around. We were just messing around. And because there was no physical bruise, she didn't die. She didn't pass out. The judge minimizes it.
He misses the entire point of the action.
He fails to see the terror. He fails to see that the purpose of the bag wasn't to kill her. It was to show her that he could. That is the very essence of coercive control. And the judge missed it entirely.
The CWJ source also criticizes the mechanism of the court itself, the Scott schedule. Now, this sounds like boring bureaucracy, but you're saying it's actually part of the problem.
It is a structural weapon. A Scott schedule is a form used in UK family courts. It's essentially a table. Column A is the date. Column B is the incident. The judge orders the victim to list, say, the top 5 or 10 incidents of abuse.
Okay, so it's an attempt to organize the evidence for the trial.
It organizes it by destroying the context. If you're living in a regime of coercive control, the abuse isn't incidents. It's the atmosphere you breathe.
It's every day.
It's the daily surveillance. It's the look he gives you across the dinner table that makes you freeze.
Yeah.
How do you put 3 years of silent intimidation into a box on a spreadsheet marked date?
You can't.
So the lawyer does their best. They write April 4th, slap face, May 12th, through phone. When a judge reads that, they see a list of 5 bad moments over a 10-year marriage.
Which looks situational.
And they say, well, that's not so bad. Every marriage has bad moments. The document itself prevents the judge from seeing the pattern. It slices the abuse into tiny, digestible pieces that lose all their meaning.
It effectively silences the reality of the victim's life.
It forces the victim to narrate their trauma in a way that fits the court's bureaucracy, rather than the court adapting to understand the trauma.
The UIC source also touches on the political side of this. We mentioned the fathers' rights groups earlier, and again, just impartially reporting the source here. But these groups push heavily for presumptive 50-50 custody.
Right, this is a huge legislative push in many states. The idea is that the starting point for every custody case, by law, should be 50-50 shared parenting.
Which to the average person sounds perfectly fair.
It sounds fair to the parents. It treats children like property to be divided equally. I get half the couch, half the bank account, and half the kid. But the legal standard is supposed to be the best interests of the child.
And sometimes 50-50 is definitely not in the child's best interest.
If one parent is abusive, 50-50 is incredibly dangerous. But if the law creates a presumption of 50-50, it creates a massive burden of proof for the victim to overcome.
Because they have to prove why the default rule shouldn't apply to them.
Exactly. Yeah. And as we've seen, with Scott's schedules and the friendly parent trap and the bias against alienation, proving that is incredibly difficult. So the presumption just acts as a shield for abusers.
So we have a system that fundamentally misunderstands trauma. It prioritizes parental rights over child safety, and it uses bureaucratic tools that actually hide the abuse. It's a really grim picture.
It is very grim.
But we promise solutions. The sources do offer a roadmap. They don't just point out the problems. Where do we start fixing this?
It has to start at the very beginning of the process, screening.
The UIC source mentions that many evaluators use unvalidated tools to screen for abuse. It mentioned one called the 5P model.
The 5P model is a perfect example of bad science in the courtroom. It's a screening tool that looks at things like potency, pattern, primary perpetrator. But the way it's applied often ends up pathologizing the victim.
How so? Give me an example.
Well, one of the factors they might look at is mental health or paranoia. If a woman is terrified that her ex is stalking her, she might score high on paranoia.
Even if he is actually stalking her.
Yes. Or if she is angry and emotional in the interview because she's been abused for a decade and nobody believes her, she scores high on instability. The tool interprets her perfectly normal reaction to abuse as a personality defect.
So what should they be using instead?
They need to use validated, evidence-based tools designed specifically for domestic violence. The sources strongly recommend the danger assessment, which was developed by Jacqueline Campbell, or another one called the ODERA.
What makes those tools different from the 5P model?
They focus on objective risk factors for lethality and reoffense. They ask specific factual questions.
Like what?
Like, does he have access to a gun? Has he ever threatened to kill you? Is he unemployed? Is there a stepchild in the home?
Oh, so it's not about her feeling.
Exactly. These are statistically weighted factors that correlate with murder or severe violence. They don't ask, how do you feel? They ask, what is he doing? It shifts the lens entirely from the victim's psychology to the perpetrator's actual behavior.
Okay, so say we screen correctly. We use the ODARA. We identify that there is coercive abuse happening. The big question is, can that parent ever have custody?
This is the hard truth that the system struggles with. The expert consensus, supported by the UIC analysis, is that for coercive abuse, the answer is generally no. At least not joint custody.
Why not? Why can't they just share the kid and not talk to each other?
Because you cannot co-parent with a controller. If you order parallel parenting, which is where parents don't talk but just swap the kid at a neutral location, a coercive controller will exploit it every time.
They'll find a way around the rules.
They will use the lack of communication to undermine the other parent. They will manipulate the child during their time to gather information or sow discord.
So what is the recommendation for those cases?
For coercive abuse, the strict recommendation is sole legal and physical custody for the non-abusive parent.
That sounds drastic to the modern ear. We are so used to the co-parenting ideal.
It is drastic, but it is necessary for safety. Now, the source suggests that visitation with the abusive parent can happen, but it must be strictly supervised.
Like supervised by a grandparent?
No, and that's a key point. Not supervised by the abuser's mom or a friend. I mean professional supervision in a secure facility with trained staff. Or, in severe cases, contact is suspended entirely until there is solid proof of behavioral change.
And is behavioral change actually possible for a coercive controller?
It is possible, but it is rare. And the sources are very critical of anger management as a solution.
Right, because as we established earlier, it's not actually about anger.
Exactly. Sending a coercive controller to anger management is like sending a bank robber to a budgeting class.
That's a great way to put it.
The problem isn't that they don't know how to manage their impulses. The problem is they believe they have the absolute right to take what they want and control you. Treatment needs to be a batterer intervention program that specifically targets the ideology of power and control.
And the courts need to see real change, not just a certificate.
Exactly. They need to see evidence of internalized change before restoring any level of custody.
The RJS family law source also brought up non-molestation orders. These are essentially restraining orders.
Yes. In the UK, they're called non-molestation orders. They put actual teeth into the protection. If you breach it, it's a criminal offense. You can be arrested immediately. The source argues these should be standard in abuse cases, alongside supervised exchanges.
I really like the idea of supervised exchanges because the handover is always the flashpoint, isn't it?
It is. That's where the violence happens. That's where the kids feel the tension ratcheting up in the car ride over.
It must be terrifying for them.
Doing the exchange at a specialized center or a police station creates a physical buffer. It allows the child to go from parent A to parent B without witnessing a war on the front lawn.
It seems like the tools exist. We have the danger assessment, we have supervised visitation centers, we have the laws on the books. Why aren't we using them more effectively?
Because of the culture we started this conversation with, the pro-contact culture.
Bias.
The overwhelming belief that a father's right to access his child is somehow more important than the mother's and the child's right to basic safety. Until judges and evaluators are trained to understand that safety is the absolute precondition for parenting, these tools will just sit in the drawer.
This has been, well, deep dive feels like an understatement today. It feels like we've been swimming in the dark for an hour.
It's a dark topic.
But I think it's necessary. If we had to boil this entire stack of sources down for the listener who is maybe prepping for a meeting or just trying to understand how the world works, what are the key takeaways?
I'd say there are three main ones. First, domestic violence is a parenting issue. You cannot be a good father while you're actively abusing the mother. It is a contradiction in terms. The abuse itself damages the child physiologically.
That's the ACE science, the cortisol.
Exactly. Second,
Right.
the friendly parent assumption is a trap in these cases. If we penalize victims for trying to protect their children from danger, the court effectively becomes an accomplice to the abuse. We have to stop viewing protective behavior as hostility.
And the third takeaway.
Context is everything. You cannot count bruises to determine safety. You have to look at the pattern over time. You have to look at the power dynamic. If the court ignores the context and relies on spreadsheets like the Scott schedule, it will get the wrong answer every single time.
I want to leave you listening with a final thought. This came to me while I was reading the reform proposals in the UIC paper. We spend so much time in society debating mother's rights versus father's rights.
It's always framed as a tug of war.
But if we truly actually prioritize the child not as a prize to be won, but as a vulnerable human being with a developing brain, wouldn't the presumption be entirely different?
I think it would have to be.
If we know that witnessing abuse causes literal brain damage, why isn't the presumption against custody for an abuser? Right now, the burden is completely on the victim to prove why the abuser shouldn't have access. It feels like the burden should be on the abuser to prove they are safe.
That shifting the burden of proof to the person who caused the harm in the first place, would revolutionize family law. It would say, your right to parent ends exactly where the child's right to safety begins.
That's the shift we need. So listeners, next time you see a headline about a messy divorce or you hear someone talking about parental alienation at a dinner party, don't just nod along. Ask the hard questions. Ask about the power dynamics. Ask about the context. Because as we've learned today, our intuition is often dead wrong and the stakes couldn't possibly be higher.
Always question the assumptions.
Thanks for going deep with us today.
Thank you.
We'll see you on the next deep dive into the source material.